Now we're going to talk about the formalities of copyright law. There are three key time periods you have to keep in mind because they all play a role, even though the law has changed over time. Some of the parameters from the older acts are still in play. Until 1989, authors, especially foreign authors and publishers, and we'll call those people less familiar with the U.S. copyright law, often lost their copyright by failing to publish with a copyright notice or failing to renew, filing an application to renew their copyright for another term. This happened with famous authors, composers, Orwell, Stravinsky, Tolkien, Woolf. Yes, Lord of the Rings was in the public domain. We'll talk about that in a little bit, because they all suffered this fate. They did not follow the U.S. formalities. Until 1989, there was a requirement that a copyright notice had to be on all published works and every single copy of a published work. If not, the work was lost to the public domain. So, for example, Allie Author, who published her novel in 1966, and she omitted to put a copyright notice on it, that would be something that we'll talk about it. Something that looks like that C in a circle, and then the publication year, 1966, and then her name as the owner, even though she was the author, as we've learned with ownership. Sometimes author and ownership are not the same person. But in this case, our author is the owner, but you have to put the owner's name on the copyright page if it's a book or somewhere on the work. Otherwise, the book would enter the public domain, free for anyone to use. Night of the Living Dead. If there's any example of this, and even if you are not a horror movie type fan, I'm not, but I have heard of the Night of the Living Dead. I don't think I've ever seen it, but I have seen zombie films, and this was it. This was what brought us zombies today. It serves as the seminal modern zombie flick, and it's a movie that single-handedly changed horror movies forever. Prior to the release of the film in 1968, zombie movies kind of focused on voodoo zombies, which meant living victims that were turned into slaves by supernatural forces. White Zombie, released in 1932, is perhaps the best known example of that genre. Night of the Living Dead changed that by rebranding the zombie into an undead killer that hungers for human flesh or brain. It also established much of the lore that surrounds modern zombies, such as the idea of having to destroy the brain of a zombie to kill it, zombies being afraid of fire and so forth. This, to most horror buffs, is known as the Romero zombie or the slow zombie. Nearly every zombie movie and TV show, i.e. Walking Dead, since 1968 owes its roots to the Night of the Living Dead, even those that deviate from the formula. However, that might not have been the case, if not for a screw-up with the copyright of the original film that caused the movie to be released into the public domain. As such, copyright, or the lack thereof, played a tremendous role in the development of the modern zombie film, helping to ensure that the dead can keep rising film after film or TV show after TV show. So just a little bit of background how this ended up in the public domain. The first prints of Night of the Living Dead didn't use the title as we know it today. Instead, it referred to the movie as Night of the Flesh Eaters, one of the working titles. That was a working title of the movie. However, before the release, the title was changed to this version, Night of the Living Dead. But when changing the title card, the distributor forgot to put the copyright notice on the final print. So that would not be a huge issue today, and we'll talk about why that wouldn't be a huge issue today. But in 1968, that meant the movie was not protected by copyright and instead was placed immediately into the public domain. As a result, reports say that George Romero, the movie's co-writer and director, saw little to no money from the film, despite it grossing some $30 million at the box office. Some estimates say as high as $42 million, which in 1968, now it's a lot of money, but imagine in 1968. The distributor allegedly, the company that made the mistake, kept all the money. So the distributor is the one that made the mistake, and oops, they kept all the money. And despite that legal flub, the movie was still a success. It was actually shot on a budget of $114,000. And unfortunately, because of the mistake, unable to get paid, but unable to make any sequels, right? I mean, it's in the public domain. Anyone can make a sequel now. So that's a big issue. Another issue up until 1992 was the need to file for the renewal terms. You get 28, at this point, you get 28 years plus another 28 years, but you don't get it automatically. That was under the act. So that became a problem that we'll see in a little bit. Now the formalities of copyright are not a condition. They went away in 1989. This is just a little background. We're going to go through each one of these. So these rules, but the rules, like I said earlier, are still important, and there are some confusing dates. But they control whether a work published between 1923 and 1989 are under copyright or not, and it's going to depend on whether or not the formalities were followed. From 1909 to 1989, a work without a copyright notice could mean a loss of a copyright. So, like I said, don't need it anymore. Author no longer risks losing his or her copyright for failing to put a notice on a published work, but there are many practical advantages for doing that, and we'll talk about that too, with regards to putting a notice and registering your work with the U.S. Copyright Office and giving them a copy. So let's notice. This is what it looks like. The little C, then the year that it was published, not actually created, published, and the author. I have author, it should be owner. Author, owner. 9 times out of 10, the author is the owner. However, if you're dealing with a work for hire, what happens? Just learn that. The author is not. The author is like an employee, but the owner, is the employer. Author, owner. Write that down. Put that in your work. So there's an example. Little copyright notice, the year, and the name of the owner. In 1906, between 1906 and December 31st, 1978, we were under the 1908 Act. Federal copyright began. This is where this began. Copyright protection began on publication with proper notice. We're going to talk about what publication means in a minute. So, copyright protection began when the work was published with proper notice. So, if you wrote a manuscript and kept it in your desk drawer, there's no federal copyright. You might have a state copyright issue, but you definitely do not have federal copyright because it's not being published. And when you do publish it, it has to have the proper notice. If not, public domain. But importantly, the state gave common law copyright to unpublished works without needing a notice. Okay? So that is key. So what about unpublished works? They still protected? Yes, under state law. January 1st, 1978 to February 28th, 1989 were under the 1976 Act, which is the one most of our rules are coming from right now. The federal copyright protection began when fixed in a tangible medium. We've just talked about all of that. That's when the federal copyright law governed. Prior to that, federal copyright law governed published and unpublished works from this point forward. Prior to that, only published. So everything. So at that manuscript that you wrote and stuck in your desk, the moment you fixed it in the tangible medium, in a notepad, however, in a notebook on several different pieces of paper, you fixed it in a tangible medium, that's when the federal copyright law attaches. However, under this rule, the copyright law, your copyright could be lost by first publication without a notice. While you might have your copyright when you fixed it in a tangible medium, when you publish it and we'll talk about the word publication, without its copyright notice went into the public domain. And then in March 1st, 1989, and after, in the 1976 Act is still in effect, but it was amended to conform to the international treaty. In 1989 is when the United States joins the Berne Convention, which is countries have come together to kind of have some conformity in copyrights, because now, there's a lot more, work being shared back and forth in the countries. The, British authors want to sell their works in the United States and back and forth, so we have to have some conformity. And at that point is when the U.S. drops the formalities. You're no longer required to put a notice on or even register your work or give the Copyright Office a copy. But we'll talk more about that and what the benefits would be to still do that, because none of those things were required in any other country. That was just the United States. So works, let's kind of flush this out. Works published between 1909 and December 31st, 1977. This applies to published works, not the ones you place in your desk drawer or have no, you wrote that song, or even if you recorded it on something, a phono record, it would have to be during this time. There's no CDs and there's no MP3 files. And you just stick it away in your closet, in your drawer. It's not going to, the federal copyright's not going to apply. You only have state copyright protection. So protection was secured by placing the proper copyright notice on copies of the work and all the work copies when it was first published. Remember that? Our little C. You could also use the abbreviated copyright or the word copyright, and you need the year of publication and the author. And I am going to stress again, owner. Owner is the one that goes on this. Okay, you might see this question and you might be looking at my slides. I hope you're writing it down. Owner. 9 times out of 10, like I said, the author is the owner. But if you have a work for hire situation, it's going to be the owner. If you created a software for Apple, Apple's name is going to be there, not yours. So this applied to all works: literary, music, dramatic works, maps, artwork. You needed to put it, initials were okay. And it's usually found on a title page of, the title page of what you're working on. So the big question was whether publication without proper notice outside of the U.S. divested the owner of copyright protection, stripped it of its rights. And the answer was yes. And the courts were actually split of whether or not this applied to foreign works published outside of the U.S. and not published here with no notice afforded protection. But the general idea was no, they fell into the public domain. And to give you a little background on the Lord of the Rings, that was in the public domain. And the court we'll talk about the actual court case, but I want to give you the facts now so we can put it in a context. And this issue, it's no longer in the public domain. And I want to give you, I'm trying to find my facts here. So in January 1, 1996, right, just in time before the movies are going to come out, there were people who relied on the Lord of the Rings being in the public domain status before it was restored. And the issue was whether or not, that the court heard was whether or not they were allowed, Congress was allowed to then take it out of the public domain. Because there was people who were relying on it. People were making copies and selling the first the first book. They were creating derivative works or other works based on it, like a film, an adaptation. And the question was, can that continue? So what happened was the first volume of The Lord of the Rings was published in the United States in 1954 with only about 1,500 copies. Even though The Hobbit had done very well, Tolkien's publishers did not anticipate what a huge blockbuster success The Lord of the Rings would be. As a result, the copies soon sold out, and instead of running another U.S. printing, the Tolkien's publisher imported more copies from the UK to fill the demand. But apparently that was a big mess up because they imported too many, because the U.S. copyright law at the time contained a protection clause that manufacturing for the books had to be done, that the manufacturing of the books that were going to be sold in the United States had to be printed in the United States. A paperback publisher discovered, and they were printed without the copyright notice on it, and they were printed outside of the United States. And somebody caught the error in 1965 and began printing the trilogy without paying any royalties. So that's where it remained, book one of The Lord of the Rings, until 1996, when it came out, like I said, just before the movies. And I'll talk about that again when we get to how that happened. So why should we have a notice requirement? Right? Want a copyright holder to take relative easy steps to preserve rights. That's what the government wanted, right? If you want to have protection under federal law, well, why don't you take some steps to preserve your rights? Put others on notice that the work was copyrighted. It's kind of like a no trespassing sign, right? Don't come on my property. Don't touch my property. It's mine. Identify the author, right? So if you wanted to use it, you can, the owner, identify the author, owner. The statute uses the term author, but it's going to be owner. It has been defined by courts as being the owner. Identify the author, owner, so that you could seek permission. Provided publication date so you could figure out, when the duration, how long it's going to be under copyright law before it gets to the public domain. Provides an incentive to the owner to claim the right if they wished. And however, requiring all of these things resulted in a harsh forfeiture, though, of the right, because if you failed to meet the requirement, you lost it. Harsh results, where the work goes into the public domain. And the statute did allow for some excused failures. So if you sought to comply, the omission was by accident or mistake of the prescribed notice from a particular copy or copies, did not invalidate the copy, but you must have attempted to comply. Not knowing that there's a consequence isn't enough. You have to know, you have to have made the attempt to comply. And it must be a small failure. So a few copies didn't have a notice, 3, 4, 5 copies didn't have a notice, but if you do a huge printing without a notice, that's not going to help you either. Well, it might be a common issue or a question, right? Publication without the notice is the rule. So the question is whether the work was published. Was the work published? We got to answer this question. Was the work published? General publication. That's what we're looking for. General publication, meaning that the work be made available to the public without regard to their identity or what they intended to do with the work. If there is general publication and you don't have a notice, then you've lost it to the public domain. This allows for, let's say you're an author and you're writing a book and you wrote a manuscript and you want a few of your friends to read it, or you want to have a publisher read it and print it, right? You're not making this general publication, but you're showing it to somebody. So we're looking at general publication. There is no forfeiture of the work if it's just for a limited purpose, right? A select few, limited publication. So the work made available to only a select few for limited purposes. Colleagues reviewing an academic paper, like I said, or somebody reviewing a manuscript. Factors that are considered when determining whether or not this is a limited publication: the number of recipients. How were they chosen? What restrictions were placed on the work? Whether the work became distributed even further. If an author sold copies of a short story to the public without a notice, in the public domain. We have an author that distributes some copies to members of a writing class for critique with instructions not to show it. Limited purpose, right? Limited purpose. We have this concept that we're going to get to in more detail when we talk about specific statutory rights. And two of the rights that we'll get into is right of performance and right of display of a work. But we're talking about, so I don't want to confuse it, we're talking about what constitutes general publication for purposes that there needs to be a notice and hence the protection for federal copyright. Make sure you keep that in mind as we're working through this. That's what we're talking about. So, public display, because we say what's limited purpose. Let's talk about public display. If you permit or display your work in any way where the idea is there's no control, where there's unrestricted copying, and that's allowed, you put, painting, movie might fall into this category, possibly, where this is where it falls into the public domain, right? There's publication. But let's say you're putting your work on display, your painting, your photography, whatever it may be. What if there's a restriction that said no making copies? You can't make copies. Do not distribute. I own this, right? That would be no publication. That would be considered no publication, and you still have the right, copyright under the federal copyright if and when you go to officially publish it with a notice, because we're talking about it hasn't been published yet. These are what constitutes publish. Performance of a work. We're going to talk in more detail next week on what performance is, but let's talk about performance of a work. What might be a work that needs to be performed? A play, a musical, right before an audience, maybe a speech, giving a speech in public. The Supreme Court says no matter what, no matter how public these things are, play, musical before an audience, performance is not publication. Maybe you're playing some songs for a group of people. So what's our distinction between display and performance? If a work is displayed, and there's only so many types of works that can be displayed. We're usually talking about photography, paintings, sculpture. If displayed, it's not difficult to provide a notice, copyright notice. It's not difficult, right? You could just hang a sign. You could pass out notices. People come in. The notice is harder to integrate into a performance, right? You can't pass out copyright notices to everyone. You can't have performers wearing, copyright notice t-shirts. It's been deemed harder. And this is what the courts have said. So we got something on display, and it's in a situation where there can be unrestricted copying and no heads up. You got a general publication. If you have some sort of notification you can't make copies, then you've preserved your right. In any sort of work that has to be performed, doesn't matter. Performance is not publication. Okay? Keep those rules kind of separated. So what if we are in an open and public place event, a big old park, and there's a big old event going on? Kind of like Martin Luther King's speech, right? I have a dream speech. Martin Luther King, I have a dream speech, is not in the public domain. Okay? Not in the public domain. Everyone wants to use it. Got to get permission from the estate. And this is why it's not in the public domain. On August 28th, 1963, Washington, D.C., where Martin Luther King, delivered his speech publicly to a large audience, both live. It was televised. And he had never submitted to the Copyright Office for federal protection. No federal protection under the copyright. At this point, he's only had state protection. Therefore, it was argued that the work was published to the general public when he delivered the speech, with media coverage, and by doing this, it was placed in the public domain, and therefore it can be freely copied and distributed. Okay, that's the argument. The next month, he does register the speech as an unpublished work with the appropriate information. So CBS is going to use it, and his estate sues CBS after it's used. They used it in a documentary series and didn't pay royalties or get their permission. And on a side note, right before he gave the speech, he gave out a few copies to the press beforehand. And the ruling was public performance is not general publication. By giving a speech in public, he did not forfeit his copyrights. This was because this was in this case is in the 1990s. Yep, 1999. And the speech is happening in 1963. Its review is under the 1909 statute. And what had happened here consisted of limited publication, right? Can you see how hard this would be for him to give out a copyright notice to the public before giving his speech? This is considered a performance. And the fact that he gave out a few copies to the press, was that a big deal? Would that change it? That doesn't change it. We have general publication in two ways. Tangible copies of the work distributed to the general public in a manner allowing public to exercise control, right? Ownership and control over it. Do we have that here? Nope. Number two, when exhibited or displayed in a manner to permit unrestricted copying by the general public. Do we have that here? No, right? Display, performance. Court says no matter how broad the audience, it is not publication. Distributing to the media as opposed to the general public for purposes of enabling the reporting of a newsworthy event, that is limited publication. So it doesn't result in the loss of copyright protection. So, Martin Luther King speech is not in the public domain. What about derivative works? Do we have an issue with derivative works? Whether a work was published when a derivative work based on the work was published subsequently. Think about Harry Potter. There's a book. And what came next? The movie. The movie's considered a derivative work. Allie Author wrote a short story, but she didn't publish it. But she permitted Patty Playwright to write a play based on her short story. And the play used large portions of the story, including plot, characters, and most of the dialogue. So the question is the play, and then my question is, play is published without a copyright notice. Is there any copyright protection? No. For either one, it goes to the public domain. The play is published with a copyright notice. Is the play protected? Yes. What about the short story? Is the short story protected now? Because the play is based on the short story? It's kind of a trick question. The courts are actually split on the issue, so either answer will do. And that issue hasn't really been decided. But then the question is it still protected under state law, which it would be if it's an unpublished work. We're talking about federal law protection here. So the short story, while it's questionable whether it still has its protection under federal law, the courts are split, but the unpublished story would still be protected under state law. I know this stuff is going to start to get confusing. You might have to listen to this a couple times. I'm trying to go slow and explaining it more than once. So publication must happen with the owner's authorization. This is another key. Publication must happen with the owner's authorization. If your work is published without your permission, without a notice, you don't lose protection. Also, if publisher had permission to publish work and promised that the notice would be put on it, but forgot, and I use that in quotations, but forgot, still protected. Still get protection because the contract required it to be put on and you relied on somebody else to do it. And if your work is stolen and published without the copyright notice, you will still be protected because it was done without permission. Okay? Sound recordings, they have a special rule. And we're dealing with this is between 1909 and 1977. They have special rules. Does distribution of sound recordings constitute general publication of the song works? Okay, we're talking about, does distribution of sound recordings constitute publication of the musical works that are embodied in them? I.e., if you don't have a notice on the sound recording work, does the song go into the public domain? Distribution of phonorecords, we already defined what phonorecords were, does not constitute publication of the musical works embodied in them. Generally, you'll see the copyright notice well, it's a little hard now because a lot of music is streamed and downloaded and so forth, but if you have a CD handy, you can open up the label and you will see that all the songs have their copyright. Each individual song has their copyright notice, and there's more than one copyright notice because you actually have the sound recording and then you have the one for the musical work inside. You can see where this thing can get pretty convoluted, requiring notices and on publication and on it being published versus not being published. So as we switch gears and talk about the next areas of the statutes, you will see why it's probably a good idea not to have all of these formalities, or at least not losing your work as a result of not having all of these formalities, but you will also see that it's probably a good idea to have these things in place. So sound recordings, special rule, it does not drop the musical work into the public domain, which would really help Ellie, author in the short story too, technically, because it sounds like a similar concept, but unfortunately it's not the same concept. And we're going to talk more about music, sound recordings, and music, the musical compositions in a couple weeks. So next up is going to be works published between January 1st, 1978 and February 28th, 1989.